And welcome to podcast episode 4 of the Gutter Nerds podcast. Today, the Skogan, the Supreme Court of Gutter Nerds, is in session. This is our first session. We will be describing some lawsuits. We will be discussing some lawsuits in the gaming sphere. And my name is Chief Justice Steve-O. Joining me today is Justice Chuck.
The attire in this room will befit the dignity of this court.
My robe is on the way. And joining us is Regular Justice. Regular Justice
League.
Lauren.
Of the
Justice League Lauren.
Of the league.
Yeah. When you guys are on the podcast together, because your name is Lauren Buck, I think I'm going to call you Chuck and Buck. Yeah.
I saw that coming a
Fine.
mile
I
away.
like Chuck and Buck.
It's not my favorite thing, but okay.
The first case on the docket today, I will put forward, is Nintendo versus Universal.
Okay.
This was one of the first major lawsuits in the gaming sphere, and
Probably the biggest one at the time, too.
it
This was huge.
It was one of the biggest ones for a while, and made Nintendo sort of what it is today in that powerhouse kind of way. So what we'll do is I'll describe to you guys what happened, and then we will all sort of pitch in our ideas and thoughts and discuss and go from there.
Okay.
And
you
since
gonna
our
play with
producer
your
is out
foot?
today, I'm going to
No.
run the board.
Thought I'd ask.
It is an important question to ask, yes. And yes, I do understand that even though I just said court attire will be essentially Sunday best, I do realize that I am in fact wearing flip-flops. This would never be allowed in any court, not even a municipal court.
I'm barefoot.
But like I said, I didn't say it would be Sunday best. I did say it would reflect the dignity of this courtroom.
That is true. That is what you said.
Behold the dignity of the court.
So, Nintendo vs. Universal, we'll jump right in.
Listening.
Shigeru Miyamoto created Donkey Kong in 1981. Randy Rissman, president of Tiger Electronics, saw the game on a trip to Japan. He went to Universal Studios because he was thinking it was King Kong. He wanted to acquire the rights to King Kong to make the mobile Donkey Kong game. So already...
And somebody at Universal said, wait, what?
I don't know if it was a direct result of this, but soon after, in 1982, Universal performed a routine trademark report. Now, I can tell you what a trademark report is. This is pretty normal for companies to do. What they do is they have teams of lawyers that periodically do trademark searches. Anything that comes up in terms of a trademark that's been applied for will pop up, and they can see if it's similar to their name, if they have similar services, and so on and so forth, and then they can choose to object to that trademark or not.
Now, remember, this isn't 2016 like when we were dealing with Rovio. This is 1982. So computer systems are still kind of working their way up to this kind of database, and they're certainly not internet accessible because
That's true.
there
I didn't
really
think
isn't
about-
internet.
I didn't think about the fact that
people
it
forget
was
about
different
that.
back then.
Like Texas property code was significantly improved with the invention of the internet in massive databasing. Because you have, in order to properly own land in the state of Texas, you have to trace your title holder through every proper legal owner of that title all the way to when Spain owned the state.
Interesting. So that's actually not entirely, that's not too far divorced from what happens here. Sid Sheinberg, so I know these names aren't really going to mean anything to you. He's the president of Merchandising Corporation of America, MCA, and Universal.
Mm-hmm.
In coordination with his lawyer, Robert Haddle, they saw this as an opportunity to sort of, these are Shark's terms, ninja/bully their way into video games due to similarities for the movie. So they saw it as a profit-making motive specifically.
As a business, you would expect such things.
That's true. So Sheinberg meets with Arnold Greenberg, the CEO of Coleco. Coleco
Making
was
the
in
ColecoVision
talks
right
with
now.
Nintendo, and they were making ColecoVision, but on top of that, they were doing some merchandising stuff with and for Nintendo.
Oh.
So Sheinberg meets with the CEO of Coleco. He threatened him with legal action if he didn't pay royalties on the King Kong likeness. Greenberg panicked because this was bad news for ColecoVision. It was going to ship with Donkey Kong prepackaged in it. So he agreed to a demand. The demand was, as a covenant not to sue, in exchange for 3% of Coleco's gross revenues would go to Universal.
Wow. Well, it just says Coleco's gross revenues as a whole. not just as a result of sales from Donkey Kong.
These cliff notes may have left that out.
Okay.
It could be specifically Donkey Kong sales or sales of the ColecoVision packaged with Donkey Kong 3%, which is a not insignificant amount of money.
No. However, depending on what they're actually asking for, it could be a more or less significant amount of money. And this, my friends, is why the legal system, no matter where you go, is always so boringly dry and detail-oriented. Because even the slightest detail change is almost like putting a decimal in the wrong place in accounting. It can add up to a lot in the long run.
And hey, Apocalyptic Zombie, welcome
Hi,
back.
Azam.
We're going over Nintendo versus Universal case right now. Universal issues the demand to cease all marketing of Donkey Kong at this point, account for all profits made, and destroy current inventory in relation to Donkey Kong.
Wow, destroy?
It was like a scorched earth, like fucking
Holy
policy
shit.
at that point. They were aggressive as fuck about this.
Well, yeah, this is King Kong. This is the thing that put Universal on the map.
So in May, Nintendo meets with Universal and Coleco.
Okay.
Minoru Arakawa, the president of Nintendo of America, was there with Howard Lincoln as legal counsel. Again, I know these names may not mean anything to you, but
Howard Lincoln eventually replaced Minoru Arakawa.
so Haddle, from the lawyer from Universal, demanded Nintendo pay royalties on Donkey Kong, and Lincoln replied, and this is Shark's note, using a wheelbarrow to carry his balls of steel, we are not going to buy the Brooklyn Bridge.
Nope.
Nintendo found many unlicensed uses of King Kong and had no evidence that Donkey Kong breached any of Universal's rights. Lincoln requested Universal submit a legal document called a chain of title, which is what you were referring to a minute ago, to demonstrate Universal's ownership of the name, story, and character of King Kong.
Wow.
Such a document was never produced.
Oh!
So
This is why you keep up with your paperwork, boys and girls.
it gets a little bit, it gets funny.
It's
The reason-
already
already
funny.
There's a reason why they don't have this file, and it's funny.
There's a... Oh, I gotta hear this. Now, why would Universal Pictures, of all people, not keep a file this important?
Right. So, let's see. Where was I? Nintendo was unaware of the agreement between Coleco and Universal, that 3% agreement.
Okay.
Coleco didn't advise Nintendo reps of the agreement. It was understood if Coleco could convince Nintendo to settle, Universal would reduce the royalty rate. So, there's a little bit of extortion there.
Didn't they not reveal it because they didn't ask for it, or did they
I
not
don't know if
reveal
they
it
didn't reveal
because
because they didn't think to, if they just thought it was their own problem. But Universal's like, we'll bring down the royalty rate if you get Nintendo to settle with us. So then Coleco and Nintendo are
Have it out
at this
with
point
themselves.
get together and having. So Nintendo refused the claim to King Kong and wouldn't pay royalties. Scheinberg, who is on the Universal side, furiously/foolishly shouts, "You'd better start saving money to pay your attorney's fees. I view litigation as a profit center." So
what?
coming straight out with the, we're just trying to make money. We're not actually trying to protect what we think is ours.
What an asshole!
Yeah.
Oh my
That
god!
sounds familiar, doesn't it?
A little bit. And
This whole story sounds vaguely familiar.
assholes getting it. In June of 1982, Universal filed suit against Nintendo for copyright infringement of their right to King Kong, with Universal's issuing of a cease and desist letter claiming all rights to King Kong to several of Nintendo's licensees, like Atari, Milton Bradley, and others.
As you would expect.
As a result of Universal's interference
yeah.
with these licensees,
I forgot they made a Donkey Kong board game. I used to own it.
and Nintendo's ability to secure other licenses, Nintendo lost about $94,000 and change in guaranteed royalties with the cease and desist having been issued.
Okay.
So Lincoln, on the Nintendo side, hired a man named John Kirby to represent Nintendo.
Remember that name, Kirby.
Additional
not good.
research uncovered that Universal didn't own the rights to King Kong. In fact, in 1975, Universal Studios wanted to do a remake of the King Kong film from the early 20s, I think. They went to court, and to be able to make the movie, they said that King Kong was part of public domain.
Wow.
And convinced the court that King
Oh,
Kong was
shit.
in public domain so that they could make the movie.
I forgot.
Then, after it getting it into the public domain, then tried to sue Nintendo for using what
What
has
was
now
public
come
domain?
to light as a public domain character.
Wow.
Right.
And if I remember correctly, I believe public domain kicks in 50 years after an unregistered copyright continuance.
I tried to
think.
look up what it is now. At the time, it was 40 years.
I think now it's probably closer to like 75.
I think they
They just
pull this
keep
shit out.
stretching it
The
out.
thing is, public domain really benefits everybody. It benefits, well, I guess, I love the public domain. It is a way for art to become part of the public conscious, for other people to utilize that art as they see fit.
I was just about to say they do that at the cost, literally at the cost of their own profits. They make that public domain, and the only thing that they can get out of it then is like revenue from ticket stubs. But anything past that, like DVD sales and such, out the window.
Right.
Like George Romero, Night of the Living Dead or Day of the Dead, Dawn of the Dead, like the very first one, the black and white one, that one is entirely public domain because he did not properly file his copyright.
And there are a lot of things. Like Shakespeare is in
Shakespeare's public domain.
A lot of the things that Disney bases their movies on are actually in public domain.
A lot of Aesop's fables, yeah, Grimm's fairy tales.
Apocalypse Zombie says, when did Gutter Nerds become a law comedy? And Game Guy says, when Gutter Nerds was made, probably.
Believe it or not, you're a lot more accurate than you think.
This episode was planned a while ago, guys. So basically, that's what happened there, is it came to light that King Kong was public domain, on top of which they were able to use the phrasings that he had said about using litigation as a profit motive against them. They countersued them for damages and for monies spent on it. Nintendo wins, and the reason that Coleco kind of shuttered or buckled at the beginning is because Universal's such a big fucking company. At the time, Nintendo is very small, so the little guy completely takes on the big guy and wins.
They're not just small; they're coming off of the video game crash. Like this was right there. I think it was right about when it happened.
Right.
And Nintendo is about to save the video game industry's life.
Game Guy says, "How are you, Lauren?"
She's
I'm
half
taking
naked.
it all in. Oh,
She's
stop
half naked.
it. I'm taking it all in.
Okay, good.
Because I had no idea. This I had no idea about.
There's your frame if you guys want to see where you are. You know.
Well, I
you
couldn't
need
see
me?
you. I feel like I need to talk to you.
Sure, that's
because I'm
totally fine.
staring at the back of Chuck's head like,
What's wrong with the back of
disagreeing
my
it.
head?
Nothing, but that's all I can see of
Exactly.
you. So I'm just
Want to
like,
see more?
Would you like to know more? So this is, as a little postscript here, Judge Sweet rules in favor of Nintendo, criticized Universal, of course. Nintendo claimed their damages. Coleco and several other companies also later filed suit against Universal, and Universal settled with most of them. And Nintendo was able to establish itself as a legitimate company capable of taking on the big dogs. Nintendo thanks Kirby by buying him a $30,000 yacht,
And
or boat, excuse me. It is called the Donkey Kong.
nice,
And it has never been said outright, but it is very likely that they named their Kirby character after John Kirby. Did I say his name right?
John Kirby.
John Kirby?
yeah.
Was it John?
I would think his name.
I think it's
you
John
did say
Kirby.
John Kirby at first.
Okay. Yes, I did.
Proper paperwork. This is why you keep track of proper paperwork.
And you're getting in trouble on the main screen.
For what?
Chuck has pulled the asshole that steals your place at the bar move on Lauren. And Dragonfly says, hey now.
Because you said, would you like to see more? That's what I'm assuming.
I think it was one of those. So, how do you guys feel about this ruling? Was this the outcome? Was this fair?
I mean, in my opinion, it wasn't a full jab at King Kong, but I mean, yeah, there are some kind of similarities. Now, I'm also comparing it to our
particular
Rovio
issue.
case.
Yeah.
And, like, granted, up until the suit was filed with us, we had nothing to do with those stupid red birds.
To be fair, like just so everyone's aware, they never filed suit. They never filed a suit. It was
But they
merely
threatened.
That's because
threats and stuff like
they were playing chicken with us, and we're the ones that blinked
And
at the last second.
that. We and you know
We kind of jabbed the dragon at that one.
we poked corner's nest, but we'll get into that a little bit later too. And if you guys have any questions on that, we explained a lot of it, but when we shut down AC, but we'll go over a little bit again.
But like I said, it's the
One of their
comparison
defenses
for
at
us.
first was that the word Kong in Japanese means great ape, and it's been sort of like nobody really knows where donkey came from, but in Shark's research, they think that it had something to do with them trying to find an English word for silly or stubborn or something like that. Now, I don't know Japanese. You know, I imagine that the Kong, you know, wording there, but Kong is not a common word.
No.
You don't use it every day. And again, if Universal, except that they knew it was fucking public domain.
No, they didn't.
They did.
Who did?
Universal's
Universal?
lawyers, because they had just not 10 years earlier.
No, I don't think they did. I think they completely glossed over it.
You don't think that they knowingly,
You just said they didn't keep any of the paperwork.
because there was no paperwork to be kept. It was
There
in
was
public
no
domain.
paperwork to be kept, which means it wasn't on the files. And they didn't think that because there was no paperwork, there was no copyright. They did not put that together until the last second. They were probably scouring their files, high and low, looking for their title claim to the copyright, and they couldn't find it. And then they realized that's bad thing.
I
That
see what you're saying.
That sounds bad, but you have to remember that everything has to do with paperwork. So if you see it on paper, it exists. It's just the
I feel
thing
like
is,
someone in that company had to know that they did not own the rights to King Kong.
this was a movie from 1925.
But they had just made their movie in the 70s.
They
And
were
now we're
trying
in
to
the early-
remake the movie in the 70s.
No, they remade the movie in the 70s, 75, 76, somewhere around there. And then, so they, not 10 years ago, argued that this belongs to everybody. And then less than 10 years later, go, actually it belongs to us. You're saying that there could have been a legal team transition or something
in the course of
those-
50 years, I would say
in
there
the
was
10
several.
years, in the 10 years.
10 years.
Yeah.
Okay. Well, I would say not only that there might have been a shift and there was a fault of communication, but that fault of communication would have doubled by the fact that like I said, everything has paperwork.
Yeah.
Everything has paperwork, and the legal system is so based around being able to prove things through paper that they don't think of the corollary where you cannot prove things without paper.
You can do it, Sam.
That's what I was afraid of. I was like,
So,
do we need to wear the robes the whole time?
because
Or
it is getting a little warm in here.
in here?
Mine's fuzzy on both sides. So,
I'm just getting a Dawn mine right just now.
okay, I'll wear it.
Yeah.
Oh, it's green.
That's
Thank
green.
you, Sam.
That is yellow.
That
Is
is
it?
that is gold, my friend.
It
So
looks green from this angle.
It's
do we
puke green.
agree with overall we
I
agree
certainly-
that the right thing happened in this
Yeah.
case?
I,
Is there? But you have
in,
dissent somewhat.
in my particular case, like in my particular opinion, okay, change words. Not case, not opinion. Experience. In my experience, it does not matter. It does not matter.
Crazy Cat Lady yells, "It's gold!" It
Yeah.
starts right
It
gold.
doesn't. It
I'm
does not matter
responding.
whether or not it is right or wrong. What matters is whether it's
Is it
provable
Trek?
or not. And we'll get to that here in a
Okay.
little bit.
Okay.
But the thing is, like I said, everything has paperwork. If you can't provide the paperwork, you cannot prove that you are the owner of that copyright. So even if the copyright were still viable when they were trying to make their movie, and even if the copyright were still viable if they were trying to secure the rights to Donkey Kong, the fact that they could not produce the paperwork, the fact that they could not produce the proof that they own that copyright means that It does not matter. That copyright is, for all they know, up in the air. But since Universal, could not prove that they owned it, they could not claim rights to it.
Okay.
That's how this whole system works.
I'm also very biased. I love Donkey Kong. So.
Now, see,
And also,
I'm over here trying to
going to
be as judicious
differentiate.
as possible.
But I'm also going to differentiate. I do love the arcade version that first came out for Donkey Kong, but I also love the handheld versions that I grew up with. But some people are like, no, the arcade version was better. No, both were very great.
All right, Justice Chuck.
So,
what would you like to present to the court?
I present to the court, probably the court of public opinion at this point, the case of Sega versus Accolade. We're going to flash forward to 1992. If you would please pull up the picture.
I will pull up the picture.
You will pull up the picture. Judge's Exhibit, since this is my show here. Judge's Exhibit A. Those of you who are old school gamers, especially from the Sega era, you probably recognize this screen. This screen was Sega's attempt at DRM back in the early 90s. They were aware of a massive piracy industry happening in Southeast Asia, and they responded by a two-part thing. What they did was they released a brand new Genesis completely under the radar, didn't tell anybody there was a brand new Genesis. That was
A
able
different model of Genesis?
It wasn't a different model. It was the same model, but they had to change the programming because they also changed the programming on the cartridges where it would have a DRM code on it.
So this screen is from the original first gen or the second wave of...
This is actually from the Genesis 3. This is from the third wave. If the cartridge spat this out and then the Genesis read it, the Genesis would play it. If, however, an unregistered cartridge got put into the Genesis 3 and it did not have the code that produced this screen, the cartridge would not play. It did a cartridge check.
And on another day, this goes a little bit with, and we'll discuss on another day, Nintendo versus Tengen.
Yes.
Which...
It's a very similar case.
So the idea is that people were making carts to play in the Genesis that Sega had not approved.
Right. You have to understand that it's not only to protect their copyright, it's also to help them make money. Because when you make a game for a system, you have to buy the licensing for the system in which you're making this game. Which means then that if they're charging, like Sega did at the time, the guy running Accolade at the time said that they were charging $10 to $15 per cartridge. Per cartridge. So if you're like a AAA title back then and you're selling several 100,000 cartridges, that adds up. And Sega gets all of that money because that's licensing.
Okay, so it's not... So DR, and Game Guy points out, early day DRM, sort of.
It is early day DRM.
A little DRM, but also Sega gets to take a little bit of every game.
That is protection of their copyright.
Interesting.
So what happens...
Real quick, Space Kitten says, I love your robe, Lauren. Why do you have all the cool clothes?
Because she's a very fashionable judge.
This also leans back to my My Chemical Romance and Panic at the Disco sweaters that I bought. But yeah, I like to be...
You got them all at the same time?
No.
They would have been the same color.
Oh, well, close. One's black, one's gray, but...
Well, see, there you
I
go.
mean, they're coordinating. But I love Target, and Target loves me. And when, when Target loves me, I buy all the clothes.
I love them back.
So, back to the case.
So we're going to go to Accolade.
Did Sega... Yeah, go to Accolade.
We're going to go to Accolade now, who discovered that Sega had done this not only to their systems but to their cartridges as well, and they did this because all they wanted to do was take that screen and put that at the beginning of their cartridge, so that they could still get the money for the licensing.
Did Accolade put this on the carts without Sega's approval?
Yes.
Oh shit!
It gets better. It gets better. They actually lost the first time this case went up.
Who did?
Sega versus Accolade. The courts found for Sega because the last nail in the coffin, like the silver bullet, was Sega produced 2 copies of a game that they didn't tell anybody didn't have the code. And they put it on a Genesis that did not need to read the code. Because remember, this is the Genesis 3, super quiet. You can't tell the difference between the two.
Okay.
So they put this in.
Oh, so Accolade's game goes in the original one and pops out the image when it's not supposed to?
Close. They proved to the court that you don't need the DRM to play the game. But you actually do need the DRM to play the game. And the way Accolade found it was they reverse engineered it. Important term, reverse engineering.
Okay.
They had to reverse engineer the original Sega cartridge, figure out the coding that produced that screen. That was when they found out that there was the DRM. So they took the whole thing, including the DRM, and put it in the front of their cartridge so that you could continue to play it and circumvent the licensing fees.
In a roundabout way, they copy-pasted Sega's code?
Yep. That actually, they didn't even roundabout it. They literally copy-pasted Sega's code. That was how that worked. And then when they went to court over it, they did this thing where, oh yeah, this is totally what you have to do, but looks like you don't need the code after all.
So Sega lied in court.
Sega lied in court. And so when Accolade appealed, because they knew that they lied in court, American case process, if you appeal, it gets kicked to a higher court. Now, they're already trying this court in the state of California, which means if you kick it up, it goes to the national level. This is the Federal Circuit Court of Appeals at this point.
Right.
This is almost the United States Supreme.
Yeah.
This is getting the feds involved. This is almost the Supreme Court of the United States. Almost. So they get the federal courts involved, and then they prove that that they had faked out the previous courts, which is automatically a really big strike against Sega.
Like even if Sega should have won that case to begin with, because they were so fucking sleazy, now we're just
no, remember, they had to appeal, so technically they have already won the case.
Right.
So they've kicked it over to a different court to see if they can get a different ruling. And they were just about to get it, too. Like, this was already enough. But then they went through the actual copyright process. And they realized that Sega's saying, oh, no, they copied our game. No, they didn't. Because every game that they copied, the only thing that they copied was that thing right there at the beginning that said licensed by Sega. It doesn't have any information about the game in and of itself. That is a universal screen. The rest of the game was untouched. And every game that they took that screen and put it on Accolade's own games, it was Accolade's own games, and then that one little bit right there at the very beginning that you'll never see again.
Like part of what happened with, I believe this is part of what happened with Tengen, and I didn't research it, so because we weren't talking about it proper tonight. But Nintendo would started to put, they didn't have screens like on the NES,
right?
But they did have that Nintendo seal of approval. It's a little oval, and you still see it to this day, I think, on Nintendo properties.
They would not release a Nintendo game at all unless they had purchased the right. They wouldn't even look at the game.
Right, but so right now,
Tengen figured out how to make the cartridge. Was what happened.
And but Accolade just didn't want to have to go through Sega to put games out for it,
because they thought it was way too expensive.
So we'll just make our own game. We'll copy paste the welcome code so that it will play,
and then the rest of the game is all ours.
So what happens now?
As a result of proving that all of Accolade's games are entirely their own, and the only thing that they have copied from Sega is this tiny little bit, the court decided that their product was original. And as for the actual copying of the game, they did not copy anywhere near enough for copyright claims to claim that it was copied.
Okay. So Sega didn't file because they were fighting that the cartridges could play, or maybe they were, but they did it under the guise of, we think they copied our game code.
Yep. And in a literal definition, they did. But part of defending copyright claim, there's 4 parts to it. It is how much of the original was copied, whether or not the heart of the matter was copied, whether or not the rest of it, like the rest of the program that was copied, like the copy itself, how much of that shows the original, and then the market effect of the existence of that copy.
Okay.
So in terms of how much of it was copied, it was like 2%, nowhere near enough to claim copyright infringement.
Right.
In terms of how much of it was important to the game itself, the original game, there was nothing of the original game used. So that's not enough for copyright infringement. In terms of how much of the original was used in the copy, there wasn't enough used in Accolade's games for them to say that they used the basis of our game to copy.
Gotcha.
So that's not copyright infringement.
So the appeals court then decides,
Oh yeah, like
fuck you, Sega.
And it's the last case, like the market effect. Especially when Sega went so far out of their way as to bamboozle the state court to prove to them that you didn't need that code.
Yeah.
And as such, there was no reason for them to copy it. They just did it simply out of spite.
Right, yeah.
They realized then that the market value of the existence of these games, because of their uniqueness, they were going to bring more market value into video games.
Okay, so Sega then,
Sega took
after getting struck down, they decided that the value of having those games on the system was
not Sega.
No, the
courts. Supreme Court said that.
Oh, okay.
And Sega, of course,
Sega benefits from the cart's existences.
Not only does Sega benefit, so does the entire video games industry.
Okay.
So what happens when I believe it's the Ninth Circuit Court of Appeals. I think that's SoCal. What happens when the federal court sides for Accolade on the appeal? This opens the way, for starters, for indie developers. Like, people have figured out, like, licensing is important, but you need to make it cheap, because what they're doing for you is going to build your business up just that much more, because you're going to have more unique things coming in. You're going to have more IP coming in.
And if Accolade puts out a game that someone wants to play, they'll buy a Genesis to play the game.
They will buy a Genesis to play the game.
Yeah.
And secondly, remember that reverse engineering bit?
Yeah.
The reverse engineering bit has now been defended as copyright safe.
So is that in general?
In general.
So if I see a lamp and I'm like, I want to know how that lamp works, if I can take it apart and rebuild it?
If you can take it apart and then rebuild the core of it, essentially. Like, you figure out how a lamp works, and then you create your own lamp around it that shares the same techniques.
Yeah, that in a broad sense.
Right.
I now understand how a lamp works. I can build my own lamp, having reverse engineered another one, but I can't copy that lamp.
Part of the reason why reverse engineering became such a big deal with this one was they had to discover that the only way that you could have found out about the existence of this code is if you had reverse engineered, because Sega didn't release that information to the public. It's just all of a sudden there's that black and white screen that we showed at the beginning of this case. They didn't say to anybody, hey, we're doing this because we're trying to keep people from stealing our shit. They just suddenly did it. Which is smart, because, keeping it as a trade secret means that nobody else is going to try and find a way to copy it. These guys just inadvertently did it. What this means is you have to reverse engineer something to figure out how something works in a unique sense. Like, find all the unique things that make a thing work exactly the way it does. That the actual process in and of itself, if it is copyrighted, is protectable, but that information in and of itself is free to everybody.
Sega and DRM have had
a tenuous past.
A back and forth, if you will. I remember the Dreamcast, the first generation of Dreamcast that come out, and you can tell if yours is the first generation by looking at the serial number, a model number, or something. There's a designation.
Okay.
I don't remember what it is. But the first generation Dreamcast could play CDRs, like writable CDs. And so when I was at TCU, there was a dude that just copied Dreamcast games. He had a tub of them. Just, what do you want? Spider-Man, Resident Evil, Code Veronica, blah, 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 blah. He would just, and you got it. Just all of the stacks of CDRs could play. And one of the things that it could also do is the Dreamcast, reading these CDRs, could run ROMs and emulators. So even right now, on my Dreamcast in the background, I have 2 discs, one for SNES and one for NES, I think. And I just pop it in, and on the Dreamcast, I can play like hundreds of, like it's a library of hundreds or something of games. They then, pulled that functionality from subsequent consoles.
Because that was
Subsequent
a violation.
Dreamcast consoles.
That was a violation of copyright. Because you're copying wholesale entire product and then playing it on something that's not authorized to play that product.
Right.
That's a violation of copyright. But figuring out how to do it is not a violation of copyright.
Okay. So what happens? Was that the final word in the Accolade Sega case?
Well, they
Did
settled.
anybody ended up suing? Like, was there any money that exchanged hands? Or?
There was a little bit of money that exchanged hands. Accolade actually wound up losing money, and to the tune of a couple $1 million as a result of all the legal fees.
Yeah.
I'm
Just
not sure.
a little bit of money.
Just a little bit of money.
Because
a
I
spot
was
of
curious.
cash.
I was like, how much is a little, John?
In comparison to how much Sega was making at the time, $2 million is not exactly a drop in the bucket, but
Pocket
it's not.
money.
It's,
Won't bankrupt you.
Yeah, they could take that hit. Accolade, on the other hand, being essentially one of the many indie developers at the time, they were their own little team. These are the guys that made Bubsy, by the way. Yeah.
I was yeah. Because when I think Accolade, I think Acclaim, and that's not the same company.
No. Acclaim made Mortal Kombat, and they also went to court, too.
Yeah.
But, yeah. But anyway, reverse engineering. Reverse engineering opened the way to emulation.
And like you said, indie games. So like other people can produce games for a console that's not Microsoft, Nintendo, Sony.
Right.
So on.
But the emulation started as a result of reverse engineering because people realized that it was now unprotected by copyright law for them to go in and essentially hack a console and figure out how it worked. And then that's when emulation really started taking off. It took a couple of years for them to finally recreate it onto a PC, and that's when stuff like Nesticle and ZSNES started showing up.
And Apocalypse Zombie asks, so you're saying intellectual property can't be copyrighted to an extent. And it's copyright law is some of the most complicated law there is.
They have what are called, as a result of the complication, they have what are called tests. Remember those 4 points I was talking about, where it's how much of the original was copied, whether or not the essence of the original was copied, how much of the original was used in the copy, and then the market value for it. That you have to test that. And if in the case of Sega versus Accolade, during the appeal, they discovered that it passed all 4 of those tests. And so Accolade was fine.
Game Guy said Dreamcast was an emulator, and what he's referring to, he sends this picture of this, the VMU there on the left was the memory card that also was like a Game Boy, and you could load games onto it and play them. But as far as I know, I mean, they were all licensed by Sega because the only way you could transfer data to this thing is through the controller.
They programmed it like that.
Yeah.
That was precisely, I mean, if they did not design it to do like that, then those buttons would not exist on that controller.
So what do we think then? Let's commiserate. Did the correct outcome happen?
Yes.
Do you feel that the fair outcome occurred in terms of Accolade versus Sega?
I mean, mathematically speaking, absolutely. Like they put it through the due diligence and rigor of the copyright test.
I feel like as far as adherence to the law, obviously it makes sense, and I'm
just
not
a judge. I'm sticking around with adherence to the law.
We're the Supreme Court
I mean,
governors here.
if
So we
you-
barely know what the fuck we're talking about to begin
if-
with. So take us with a grain of salt here.
If you want a heartfelt, go for her.
But
you already know where I stand on this.
I'm going to go for modern versus, what year was this?
This is 1992.
Okay, well, in the 90s, you know, obviously more laws have come into play. Everything that we now have to play with is what we're accustomed to. So in 92, I wasn't even born. So for me, like,
Oh my god.
I know.
Oh fuck! I turned
But-
33 this weekend too.
But my point is, like, so I'm a PlayStation gamer. So everything up until like the first model of PS3 was reverse compatible. So like everything PlayStation, you could play on your PlayStation regardless of how old it was. I mean, considering condition,
So if-
yada yada.
as if you-
So in my opinion,
Yeah.
for Sega, because of the modern
Yeah, because of
aspect
the way
for
you
me,
play now.
I don't think it was fair.
So,
But
so let's
for
put it this way.
law, for law, I absolutely think it's
If
fair.
Lauren makes a console called the Xbox 360,
Thank
Okay.
you for that.
let's say she makes an Xbox 360 and she has a proprietary cartridge that, you know, or something that goes into the thing and you to play. Do you think that it is fair for anybody to be able to make a game to play on it without running it by her?
No. However, I do think that it is fair for them to figure out how to make one. What you do with that information is entirely up to you. And that would determine whether
Okay,
or not
Morpheus.
But with that, I do agree. However, okay, for the Xbox 3000,
Wow,
I hate that.
okay,
360. I do believe that they have the right to figure out. However, like his friend who was just giving away games because he had the availability to, did you buy those games?
No, fuck
He
no.
just gave them to
Yeah.
you. That's different. Now,
That is
what
true.
was it?
Accolade?
Accolade.
Accolade.
Accolade made money, and from what I assume, they made a pocket
They-
change of $2 million.
they made money off of their own product.
Right,
But they can't play their product
if
without
they don't
Sega's
have,
help.
Yeah,
They
if they
just-
don't have their own Xbox 360, they can't do shit with it because if Sega
If we
decides,
made games to
Which
play
is-
on her console,
Which is why the state of California found for Sega. Because
but when they appealed, they found for Accolade.
well, but the appeal was partly based on the fact that Sega pulled one over on
Yeah.
then once they
lied.
proved that-
now granted, they did lie.
Sure. So like, you know, even if you were right to begin with, if you're a sleazy fucking douchebag,
you're going to pay for it.
Gonna have to
we
pay for
got
that.
2 for 2 on
Just
that,
to
in
clarify,
fact.
Gonna have to pay for
just
that.
to clarify, when Accolade made this game all on their own, they did use the Sega copy. Did any of the I think this was answered, but I just want to clarify. Did any of their profits go to Sega?
they didn't pay any licensing or royalties. As far as I know, they didn't
Because
pay anything to Sega.
Sega's game console is the one it played on. So did Sega receive any money because it was used on their game console? Like if Steven makes a game for the Xbox 360,
Okay.
as long as I get a little
long
bitty
as you
portion
get
of
a
that,
bit of it,
because
yeah.
it's my game console, I don't give a shit.
From the Sega v. Accolade wiki. Sega and Accolade ultimately settled April 30th, 1993. As a part of this
I
settlement,
was born.
Accolade became an official licensee of Sega.
Oh, interesting.
The terms for the licensing, including whether or not any special arrangements or discounts were made to Accolade, were not released to the public. The
So it's sort of-
financial
sort
terms
like
of the
the
settlement.
modders in Skyrim, where it's like, I mean, even though they're still not getting paid, but some of them have gotten jobs. Whereas, like, we made some shit for your game, we did it without your permission, but it's good.
Yeah.
And-
But you
And we want your help for our future games.
you can't ignore good product. Absolutely, you cannot ignore. That's why that fourth test for copyright is market effect, market value. That's why that one exists. Is because if somebody takes that and then does something really amazing with it, despite the fact that technically they sold it, that could be a mark for why they made it in the first place. I have no choice but to go in, figure out how they made this thing, and then make my own version of it because I believe I can make it better. I don't care whether or not they own the copyright to this. I can do it better,
Like the Zune.
like the Zune. I miss
Zune
the
was better.
Zune.
Zune forever. Zune was better than iPod, and it still is.
I miss
I
my
have no
Zune.
frame of reference. I'm sorry.
Well,
I know what you're talking about, but I never had a Zune. I only saw what a Zune was, and
I
it was
still have
really
the
difficult
headphones.
to.
I still have the headphone. I still have my Zune. It's in my
I think
car.
Peter has a Zune.
When I started at the Modern, I was the only one that had a Zune, and a few people had iPods. And I started with our friends John Mosley and Daniel Horn. I was like, hey, get one of these. I'm like, why? And I was like, it's like an iPod, but the screen's bigger and it plays multiple file formats instead of just that whatever
Proprietary
the
bullshit.
was. And they're like, oh,
Kind of
yeah.
fitting that we're talking about proprietary bullshit,
So,
right?
so they got theirs, and other people started singing them. And also, you could do that weird squirting thing where you could share songs with each other for like.
I'm sorry, what did you
They
call
called
it?
it
Phrasing.
they called it squirting. I think.
Phrasing, Microsoft.
They
no wonder why
had
the
they had
Zoom failed.
Wi-Fi transmitters, so when we were in the museum, I could
So
be
you
like,
could
oh.
literally have a Zune in one hand and a Zune in another,
Uh-huh.
and be like, "Oh, you want the song? I'll send it to you."
I could send you a song for like 3 plays. Like you could listen to it 3
Oh,
times, and then
okay.
it would delete. It was like
I
a
bet you
like
that's why
a
it's called
check zone.
squirting.
And there and then it was gone. But anyway, different.
Ew.
Lauren, what did you bring for the Supreme Court
What's next
for
on our
Skogan
docket?
For
today?
Skogan.
for the Justice League. Have to put on the hood for this. Okay, so
Oh, God.
because I got so stoked about The Last of Us Part 2, I thought it was only necessary to talk about Ellen Page's riot moment. So, long story short,
Do it.
in 2013,
Do it.
Last of Us came out. So, on the release, Sony was actually working with Ellen Page. I actually have her remarks on this. Sony was working with Ellen Page on Beyond Two Souls. Is that
Yep.
correct? That's Sony?
It's Quantum Dream. Yeah.
I just wanted to make sure that was correct. So, Ellen was upset because, and if you'll, well, not yet, but Ellen was upset because Ellie has similar likeness
Similar?
to her. It's similar. It's very similar.
Similar, she says.
However, even so, on the woman on the left-hand side is called Ashley Johnson, and she is not only the real likeness to Ellie, but she is the voice actress that has been working and is, I believe, still working with Sony for Last of Us.
Yeah, she is.
So, and you can tell, especially on the bottom half, because that's the remastered Ellie, that they fine-tweaked it so much that it actually does look more like Ashley Johnson than it does Ellen Page. And if you disagree, that's fine. But I
yeah.
truly believe
Okay.
that from the
We'll
original...
get to our once after this is just you know.
But
once
from
we get
the
there.
original to the remaster, that's why they did it.
Okay.
Because Ellen Page was like, you know, that looks a lot like me, like, cool, but that fucking sucks because you didn't ask me. So her exact remark,
Oh, her exact remark.
she said on Reddit Ask Me Anything, which is the AMA,
Yeah, mate.
she said, I guess I should be flattered that they ripped off my likeness, said Paige, but I'm actually acting in a video game called Beyond Two Souls, so it wasn't appreciated. So especially since she was already in a game that they were using, she felt that it was inappropriate that without her permission that Ellie remotely looked like her.
Right.
Which is understandable.
Okay. But Sony wasn't developing the game, Naughty Dog was. So, and also Quantic Dream was developing Beyond Two Souls, and Quantic Dream and Naughty Dog
Are not
would
Sony.
not have talked to each other. Now, anyway,
Well,
continue.
and Naughty Dog commented after this because especially since the first version was released in 2011, they didn't understand why all of a sudden in 2013 she's like, oh, well that sucks because she looks like me, blah blah blah. And I mean, even Ashley Johnson does sound like Ellen Page, but that's not the point they were trying to convey.
No.
Well, in my
Am I the
opinion,
only person that saw What Women Want? Because yes, I remember Ashley Johnson before
but she was a teenager
Ellie.
in What Women Want, and that's why I was like, oh, I know who that is. But if you're just playing the game and you're like, you know, this looks like a lot like Ellen Page, but I don't think that's Ellen Page, and then you look up voice acting, it is Ashley Johnson. But they have similarities voicing and physically. So anyway, but Naughty Dog said let's see. The character of Ellie has changed appearance since the original incarnation, and it drew immediate comparisons to Paige at the time as well. And Naughty Dog said that the alterations were made to bring the character more in line with Ashley Johnson, because the original was in likeness of Ashley Johnson in all retrospect, because they're paying her, she's doing the voicing. And so Ashley Johnson's like, yeah, you can use me as a frame of reference. And so, yes, it does have similarities to Ellen Page. However, when they remastered it, like the picture showed, they tried to fine tweak it even more to Ashley Johnson, but since they are similar, Ellen Page got butthurt.
Yeah.
So later on, let's see. Okay. So later on, Naughty Dog actually tweets, because majority of this was, I guess, player uproar.
Like
So
a lot
every-
of players were
all the
like, "This is
players,
clearly Ellen
after
Page."
After Ellen had said, you know, this kind of sucks, like it's my likeness. The players were like, well, you should fucking sue them. They deserve this. This is their fault. So player uproar caused more of a spur than she actually did.
Sure.
As what usually happens.
Because, I mean, she's working with Sony and she's working with the developer of Beyond Two Souls. And then she talks to Naughty Dog and they're like, look, we didn't mean to do this. We obviously meant to do this for our voice actress, for the actress herself, and yada yada. And so Naughty Dog in 2013 actually says, wow, the reaction to @Ellen Page's AMA was overblown because of all the comments and the players' reactions. So after the announce...
Man, I feel like if I were Naughty Dog, I would just not even address it.
Well, no, because she retweeted as well. I'm getting there.
okay.
And he said, or Naughty Dog said, after the announced trailer, there was initial confusion leading us to revise Ellie's look. So even after the remastered, they were still worried about this.
Yeah.
And Ellen Page retweeted and responded with, I agree, looking forward to playing The Last of Us. So clearly after the...
So she's okay.
Yeah. And so after I had found this, I was like, okay, is there actually any lawsuits? So after I did all this research on everything I found, there actually wasn't a lawsuit filed. However, I looked it up, and Ashley Johnson actually won an award for her acting.
Yeah.
And in interviews after her speech, because of course she commented on how she's so happy she got to play a female character with such an amazing role, yada yada, simple female, you know, blah blah blah. She commented on how Ellie's gay and how she's surprised that there was an uproar on that, because she was expecting a lot of hate from the players.
Sure. Yeah.
But she also
People
said
suck.
she's really appreciative, because this was, I mean, she acts obviously like what women want, things like that, but she voice acts more so now. And so for her to have received a Best Performer in BAFTA in 2015, it's a big thing for her, because now she's going to be called upon more for, you know, acting roles.
And she was already a Whedonite. She was always in the sort of side character background, and a lot of times her character would get cut from stuff like in Dollhouse. But she was in the first Avengers movie, for example.
She was in a back character role, yeah.
Yeah.
Because I noticed her, I was like...
At the very end, she's talking to the camera like, and then the Avengers, they saved
yes.
me.
Yes.
Yeah. And real quick, Dragonfly says, Chuck, I want Lowe's robe. Steal it.
Go ahead, try me.
So what...
Steven saw me roller derby, I dare you.
That's true, and it was pretty fucking awesome, too.
Go ahead, look at me like that, I don't care.
So at this point, there was never like a cease and desist.
It was
There
just
was
a Twitter war.
It
was-
was a Twitter war.
well,
and fans being
Because
bitchy.
the fans were... I think what it was because I kept seeing Twitter comments. Every time I looked this up, I saw a Twitter comment from like some random person. And so what had happened was, I guess like a Twitter... I don't know what a famous Twitter person is called. But they're not a celebrity, they're just a Twitter...
Verified?
Verified.
Oh,
yeah.
like a Twitter,
like a Twitter celebrity
personality.
Yes.
Oh.
And they had commented on Ellen and said, "Hey, loved you in The Last of Us." This was remastered, and she's like, "Actually, you need to give props to Ashley Johnson because she did a fantastic job." So
I kind of like that tweet though. It's kind of funny.
in 2015,
It'd be like it's like thinking. Well, we'll get into it here, but it's like before Iron Man. Let's say before Iron Man comes out, you know, the Marvel Ultimate Series.
Mm-hmm.
It's like tweeting Samuel L. Jackson, being like, "Hey, loved you in Marvel Ultimate Series" is Nick Fury, because they sort of based Nick Fury on Sam Jackson.
There was no sorta.
they
the
completely
Ultimates-
did.
But this is the thing, like, you can, on a famous person, you can You can certainly parody them.
Yeah.
Lindsay Lohan versus Rockstar.
Yeah. Another case I would love
You
to
can
touch
certainly parody them. And Apocalypse Zombie actually has a great. He said, "Did Ellen Page come out before or after The Last of Us?" Because the character falls even more in line with Ellen Page at that point.
In 2011, she was in. In 2010, she was in Juno.
on. No. She came out as...
Came out as gay. I mean, because
No. That has nothing to do with her orientation. It is a complete likeness, just the physical aspect of
But
her.
the
Oh no, I
thing
know,
he's
but the
saying
perception
is-
of if they based this character on Ellen Page,
They
and they're like,
hired-
no, it just looks like her.
They hired
Yeah.
a straight voice actress to also do essentially emotional mocap for a gay character. Why did they pick the actually gay person to play this character?
Well, I don't think it's even so much the casting so much as if they're saying this is not based on Ellen Page, but she looks just like her, has the same sexual orientation as her, and sounds just like her, according to the fans.
If it walks like a duck, talks like a duck, quacks like a duck,
Probably
it's a
duck.
moose.
Yeah. There honestly was nothing, from what I've read, there's nothing that compares her, I guess, emotional state or her mannerisms or anything like that. The entire basis for this argument was it is completely physical in every way. She just looks like Ellen Page and talks like her. So it looks like Ellen Page and sounds like Ellen Page. However, it is not the...
We weren't
emotional-
thinking of
No.
Ellen Page when we made it.
Yeah.
Just turns
It
out.
just turns out it's kind of
But
Ellen
is-
Page.
Subconsciously thinking of Ellen Page.
So then let's drill down to this a minute before we get to our final case. Then, do you feel that people should be able to parody famous people?
Yes and no.
Well, I was going to ask parody and then the likeness thing, because Marvel and Shadow Step says they, and as you were saying, they definitely, when they redid Nick Fury, based him on Sam Jackson. Sam Jackson didn't care and liked it, so there's no problem. But let's say Sam Jackson does care, then is that okay? Being like, we made a character that looks like you. I mean, yeah, we were thinking about you when we made it, but it's a different character. We just were inspired by you. And how is that different from parody if one is okay and not the other?
Parodies with stuff like the Seltzer and Freebird movies, like Epic Movie, Scary Movie,
Yeah.
stuff like that.
Yeah.
They have a whole lot of pop culture, like flash pop culture references, and they usually involve celebrities because that's who makes pop culture. The thing is, those parodies work because we immediately recognize them. It's part of their very image. Now, you go to Lindsay Lohan versus the Rockstar, because there's apparently a whole character that's supposed to be a parody of her. Consider this. There are two other cases. Adam Levine and Gwen Stefani both sued Activision because in Band Hero, you could make their likenesses sing other people's songs.
Right.
They did not want something looking like them not doing things that they did not do. Because
and Apocalypse Zombie, yes, parody is protected. So if we wanted to do a show parodying Captain America, like we could name
you would
it.
be Captain America.
Yeah, well, yeah.
Well, actually, they were already. Remember the College Humor thing where they got Don Cheadle to play Captain America, and
Yeah.
he was clearly Captain America. Yeah, I actually called him Captain America,
But even
and
like
then
the
he turned
College
everybody
Humor
into
stuff,
trees.
like where he's literally playing Batman, but it is a parody. That is protected.
That is protected. However, the likeness, like using actual likeness, there's a difference between saying that this is Batman and this is Batman.
And impersonators are cool.
Because again,
So,
there's a difference between saying this is Batman and this is Batman.
So I guess I should ask, because I just found this out today. College Humor actually did a funny live action version of 20 years later of a Daria thing. So it's like Daria at her 20th.
perfect
family-
casting, too.
But you see what I mean? Like, obviously it's based off of those cartoon characters that only had, what, like 3 seasons?
Well, that's
4 seasons?
at that point. It's not even likeness. It's just a reimagining at that point, and I think that is also protected in the same way that a parody is protected.
Okay.
I
Because
don't know,
it
like
is
you can't reboot someone else's property though.
No, because that is no longer parody. That is likeness.
Yeah.
That's not a reboot. That's just a reimagining.
So I wanted you to expand about the using the likeness. Like, should companies be able to do that?
I
Can
say
you
yes
make a
and
character?
no.
Okay. Why?
So like obviously, Fallout 4,
Fallout 4.
Fallout 3. What am I doing?
Or 4 with Danny Trejo?
Well, wow, I'm having such a brain fart right now.
How about Dragon Age 2?
No. I'm
Because,
going.
You
got it?
I'm doing the most recent Fallout 4, correct? I'm making
Yeah.
sure because in
Yeah.
my head that number's not making sense.
Yeah.
Okay, so like you've seen online, like there's a John Cena that you can make. Like you can make your own character. Obviously, like that's not what Fallout did. That's not what Bethesda did. But you can make that character because you can edit the jaws. You can do all sorts of crap.
Yeah, you
Yeah.
can.
And so, like, if it's not, like, obviously Bethesda has no control over if you do a likeness of John Cena or if you do a likeness of Lindsay Lohan or whomever.
Mm-hmm.
So, in that regard, tough shit. Like, sorry, that's what it is.
So what about Gwen Stefani and Adam Levine? Did they have a particular case because they made them sing other people's songs?
I feel like that's a double-edged sword because
As is the legal case usually is.
well, but so they're rock stars, they're musicians, and I'm sure that they allowed their likeness to be in the
yeah,
game.
they had to sign off on it.
So
Are they-
sucks to be them that
But-
they're having to sing other songs as their likeness
To me,
is on that
if
game.
there's a character that reminds me a lot of Gwen Stefani and was based on Gwen Stefani spiritually in the game, I'm like, okay, cool.
These are
but
not-
if they refer to them as Gwen Stefani,
Which they did.
then I have the problem. So I
they
feel like
signed off.
even if Last of
But
Us, but
they
even,
signed off under certain stipulations.
Right.
Those stipulations are expressed in the contract. Remember what I was talking about with a piece of paper? Everything is on the paper, and contract law has to be super duper specific. Somebody had to go in and say, you are allowed to use my likeness on the condition that my likeness is only used to perform my songs. If that stipulation does not exist in their contract, then it sucks to be them. But if Gwen Stefani has a case in which she says, I did not allow Activision to use my likeness to perform other people's songs,
As it
she's
says
got
in
a
my
case.
contract.
As
Right.
it says in my contract.
So
keep track
I-
of your paperwork.
I feel as if what, let's say Naughty Dog did, like, let's do an Ellen Page type character.
Okay.
And we made her look a lot like Ellen Page, and Ashley Johnson kind of sounds like an Ellen Page type.
But it's not Ellen Page.
But it's not. We're not referring to her as Ellen Page. We're not billing her as Ellen Page. People, like, that's just, I feel like that's fine.
For me,
Even if they did, knowing that she looked I don't care.
for me, I think on Ellen Page's side, it's like, well, you used my likeness. Some people might actually play the game solely because
They
Ellie
think
looks
Ellen
like
Page is.
it looks like Ellen Page. It sounds like Ellen Page.
I mean, hell,
So
her name is
for-
Ellie.
That was weird. That was the weird thing.
You know what? That's such an obvious thing. I didn't even think about it. Apocalypse Zombie says, have you done a parody comic of Angry Birds yet? We have, so sort of. We took a couple shots at Angry Birds when we were Angry Cuddles. And if you go to wukb.gutternerds.com, Washed Up Kitten Businessman has done a parody of Angry Birds called Assy Clowns. So there's that. And so the likeness thing is interesting. My thought
torn.
was,
I'm very torn.
if you take someone who's very famous and you base someone on them, but don't bill them as them, I feel like you're fine. However,
Speaking
Speaking
straight
of-
in, this is an excellent segue to this case. I really like how you did this.
O'Bannon versus NCAA is an antitrust class action lawsuit filed against the National Collegiate Athletic Association, the NCAA. The lawsuit, which former UCLA basketball player Ed O'Bannon filed on behalf of the NCAA's Division I football and basketball players, the men, it challenges the organization's use of the images of its former student athletes and current student athletes for commercial purposes. The suit argues that upon graduation, a former student athlete should become entitled to financial compensation from the games for using their likenesses. Now, here's the thing. The games don't use their names. They very explicitly do not have names on the uniforms.
They only use player information.
You can custom make names on the uniform. You can label them, essentially. The NCAA has a rule that because the student athletes are amateur players, they are not allowed to be compensated for what they do. They're not allowed to make money. We can argue whether that's right or wrong. I feel like that's wrong. They're fucking adults. They're getting the shit fucking kicked out of them every week.
In order to get a job in which they will continue to get the shit kicked out of them.
And they're making so much money for the people above them, the networks. That's a different thing, but I have thoughts on it. So the sitting judge in this case is Claudia Wilken, just in case you wanted to know.
And Steve-O.
And me, Justice Steve.
And I guess we're here.
With the help of some other players, Bill Russell being among them. If you know anything about basketball, then Bill Russell's a big name. Oscar Robertson as well. So they... The part of it also was that they thought that it might also be... they pulled up the Sherman Antitrust Act, and what the Sherman Antitrust Act does is essentially keeps companies from abusing monopolies. You can create a monopoly on your own merit, but you can't use predatory behavior to, say, price fix or things like that, because it's abusive to the consumer.
They brought up the Sherman Antitrust Act for this.
Yes, it did. So EA and NCAA, essentially, EA claimed that, let's sort of this Ellen Page thing, it looks like you, but it ain't you. Except that every player on every team matched the name, not the name, because they didn't use the name, his real-life jersey number, his position played, hometown, year of eligibility, athletic abilities based on 22 dimensions of speed, strength, agility, etc., physical characteristics on 26 dimensions, including height, weight, skin color, face geometry, etc.
Random sheet of paper,
how
please.
he dressed.
Yes, thank you.
Things like that.
They got this close to naming the characters.
Yes.
As close as this.
Here, I'll get you a little
as thin as that sheet. They got this close.
Paper.
This close to that.
Fucking
paper thin.
thin.
Now here's the thing: because they did not use their name,
they got away with it.
They got away with it
That's
because that is
shitty.
not their likeness. All they did was use their information. And
Use all their information.
I have two cases that can corroborate that as well. Fantasy football and fantasy baseball were both sued by both the MLB Players Associations and the NFL Players Associations. The NFLPA case is actually, I think, still in litigation.
So
I think still in litigation. But the thing is, the MLB case went up first. That was in like 2008, 2009. And they said that they were using the players' likenesses, and the players' likenesses were copyrighted because they were part of the MLBPA. The problem is that's factual information. Factual information cannot be copyrighted because that information is useful for everyone else.
Right.
Like, remember the reverse engineering thing I was talking about? All of that information that you find in the source code, that is information that is open to everyone, provided you take the time to go out and find it.
yeah.
Phone books.
Yes, Lauren.
So,
I'll get to that.
clarifying. The player in this case did not win.
There's
So this is what happened. They go to court. The ruling.
Also, to clarify,
Yes.
this player is now doing whatever the hell he wants out of school, correct?
So this is what happened. Wilken ruled the NCAA's long-held practice of barring payments to athletes violated the antitrust laws. She ordered that schools should be allowed to offer full cost of attendance scholarships to athletes covering cost of living expenses that were not currently part of the NCAA scholarships. And she also ruled that college be permitted to place as much as $5,000 into a trust for each athlete per year of eligibility, so that when they graduate, that money that was made is there waiting for them.
They're being paid a flat rate of $5,000 to use their likeness.
The NCAA appealed the ruling, and in that case, the NCAA was denied control of college football television rights, and the court also stated to preserve the character quality of the product, athletes must not be paid. So, the NCAA got off the hook here. Kinda. The players this last year started getting some checks from what became a class action lawsuit against EA. EA settled for $40 million, and the payments to each athlete, the median was somewhere around $1,200. It also killed the franchise.
Yep.
NCAA does not exist as a video game anymore.
Okay.
They stopped doing that. Now,
So technically, both lost here.
oh yeah, everybody fucking lost on this.
Well, in that regard, from what I was saying from Fallout 4, like obviously, if you can fine tune to all those qualities, then yes, it's not their fault. However, I would have gone for the player on this one. Like, clearly, that's him. Minus the
It's a
name.
The reason the NCAA didn't want that to happen is they are still student athletes. They are athletes, but they are student athletes. Now, these rules came up at a time when the game of football was not taken anywhere near as seriously as it is now. Especially since this is collegiate football, you're supposed to be in fucking school. You're not supposed to be in school simply to play college, and a lot of people argue about that. Like Alabama constantly mops the floor with college football, pretty much in general.
So I'm going to say that I think what happened here, the outcome was fair. I think that I'm kind of happy that EA sort of got stuck to on this one. But you guys can give your opinions here. Give me 1 minute, and then if you want to discuss any of your thoughts on Roe v. O.V. Angry Cuddles, go right ahead, and then we'll sign off. I'll be back in just a minute.
All right.
Gonna go take a poop.
He's got to go poop. So,
Thanks, guys.
what I'm suggesting here is that I kind of like that $5,000 flat rate thing. The reason why they made these rules is because they didn't want the students to be so obsessed with their athletics and to make that into a business that it defeats the purpose of going to college. You're no longer going to college for school. You're now going to college to play for a team, which you can argue it's already like that. I bring up Alabama yet again. Everybody wants to play for Alabama anymore. Who wants to go to Alabama University for anything other than football? Nobody. Who wants to, like Duke? Duke has an amazing academic program.
They do.
It's
And
one
no
of the
one wants to
best
play for
schools.
Duke.
Nobody ever wants to go to Duke unless they play basketball because Coach K is the god of collegiate basketball. NCAA men's basketball team, that dude is he's a god among men. So everybody goes, oh yeah, Duke, Blue Devils. Fuck yeah, you guys going to the finals again this year? They don't give a shit about the academics. And that's what they were trying to avoid when they made these rules, was you are a student first and an athlete second.
Well, even now, I'm gonna turn to TCU. Like now.
Oh God, the Horned Frogs.
But now, because when I was in high school, I was like, I'm not athletic. I would want to go for academics.
Mm-hmm.
Back then, all about the football, all about
Hell,
getting.
it still is. Have you seen them now?
But academics have gone way up. They've completely tweaked their academic program, and now I want to go to TCU. When I finish.
That is one good thing that comes from all the money that gets poured into really good athletic programs with national TV and these good rankings and such. As people are starting to pay more and more attention to TCU because they've been winning more and more games.
Well, we're in the top 12 now.
It's you guys are doing amazingly the past few years, and so more and more money starts coming in, not only because of TV sponsorship deals and such,
right,
but also because more students want to go to the college, and that brings in more tuition money. All that money has to go somewhere, and they still budget for athletics. The rest of the money goes to academics. So you got these really good state-of-the-art systems, and they're super clean, and they allow that to happen. Hi, did you take a good shit?
It was fantastic. Thank you.
Excellent.
So I guess on that remark, I kind of want to bring this up. I know this is kind of going off on the tangent, but in that ideology, in the chat, it was talked about fantasy football. Well, in recent years, they've started to do another type thing where it's like a potluck, And so at the end of the year, granted, in your individual fantasy football leagues, you guys can do like, oh, the winner gets $100, kind of like we do.
Okay.
But there's this big thing that's all over the world, and the winner of like the entire thing gets like $1 million.
Yeah.
Well, I don't remember who it was, but I remember Dr. Peter Pena talking to me about this. And one player, just one, out of the entire football league on both sides, said, well, that's not fucking fair. I played my heart out on these, I don't know how long a football season is. I don't know how many games that is. But like, if you played 10 games and they used you in their fantasy football league and you got $1 million, would you think it was necessary to pay that player because they technically won you that money even though you picked them?
So, like, okay, so let's say someone was going to do a fantasy betting. Someone was going to bet
Ooh.
on... But that's
Damn.
weird. It's like if you're gambling, though. It's like we're going to go bet on the horse races,
But
but
that
you're
horse
going to have
doesn't
to...
get any money.
You're gonna have to pay the
But you're going to have
horse.
to pay some of the horse if you win.
I wouldn't fucking gamble worth the shit for that.
Like, so if people were going to bet on us, and if someone created an entire empire, like a giant multi-million or billion-dollar
DeAndre
company...
Hopkins is who did it. Thank you.
Oh, thank you.
It's Dr. Peter
Dr.
Pena.
Peter Pena. And also, thank you for the fuck Rovios in there too. We'll touch on that before we go. This has been a very long one, but if someone built a side company that was about watching gutter nerds, the thing is even if they made millions of dollars, it's sort of like some of the other stuff we've talked about. It's adding value to the property. So if Game Guide creates a gutter nerds watching party betting pool, and they bet on how many fucking times I say fucking fuck, and they're betting on who...
Thank God it's not a drinking game. You kill people with alcohol poisoning.
And it ends up being a big
That'd be
company, a
fun.
multi-million-dollar company. We might initially be like, well, shit, he just made a shitload of money off of us. Don't we feel entitled to some of that money? However, he's probably sending so much more fucking traffic our way.
Mm-hmm.
We are probably benefiting from it.
In the end, we're going to make more money from that.
And this is sort of like the
Because of-
accolade thing
yeah.
earlier, is like, they're going to bring more people to your console, potentially. It's when people bitch about on Kickstarter, like Zach Braff did a Kickstarter, and they're like, oh, Kickstarter's for little people, it's not for famous people. You're taking all ours. No, they're not. They're actually bringing more attention to Kickstarter and more traffic. Since the famous people went on Kickstarter, all the little projects have seen a boost as well.
Not only that, but you forget that Zach Braff is still one person. He may be one person with a fair chunk of
He
change
may have $1
behind
million,
him.
but he is one.
But he's going to have to pay for these things entirely out of his own pocket,
So-
and he wants a little help.
We'll finish up here. Rovio v Angry Cuddles. Not gaming exactly. We weren't gaming.
Not
they
an
were gaming.
official.
This is how I feel sort of about, like, sort of the flip side of the King Kong thing. If I was going to make a movie called King Chuck, and then Universal sued me because they have King Kong,
And you just so
the
happen to
common
be
name,
king.
a commonly used word, I feel, and the courts might have found that way too if we had the tens of thousands of dollars to fight it. That is such a commonly used word, doing something different from what you're doing, even though there is a slight bit of overlap on the topic.
Mm-hmm.
We don't produce a video game,
No,
but we talk about them.
Yeah.
Anyway, so
you don't need
Not nicely.
you don't need the
anymore,
tens of thousands of
but-
dollars.
Right.
You can bring up Nintendo versus Universal and say just because you use the name doesn't mean you're using the actual license. And then there are a couple other cases like Bethesda versus Mojang, where
Yeah.
Mojang was making a game called Scrolls, and Bethesda said you can't do that because people are going to confuse that with Elder Scrolls, which makes no sense because nobody remembers actually Elder Scrolls. They remember Morrowind, Oblivion,
Yeah.
Skyrim, but they don't actually think of the Elder Scrolls. They forget that part.
Game Guy says, Steven, I just want you to know if I make a ton of money off of you, I can guarantee I wouldn't give you any of it.
But I'm just kidding.
Thanks, Game Guy.
It'll be like a 95-5 split, just so you know which half you get.
Ting!
So no, the word king cannot be copywritten, just as the word angry probably can't be copywritten.
Scrolls
or
cannot be
trademarked.
copywritten. The word edge cannot be copywritten. Here's my homework for you folks out there. Look up a man by the name of Tim Langdell, Langdell. Tim Langdell and his obsession with the word edge. Follow that rabbit hole down, see how far it goes, and understand fully how stupid of an idea it is for somebody to want to try to copyright a word.
Oh, and Peter and Sable, hello. Sable says hi.
Hi, Sable.
Only to you. Notice that.
That's
That
true.
was-
No, that was to me.
only to you.
That's to me.
Oh, well, I rescind my hi.
Saga, yeah, the word saga has come.
Saga.
This is a thing. If it is a word that is used, if it's not a made-up fucking word, and we may go, in another episode, we may go into Sky, and Sky Media, and Skype, and stuff
Yep.
like that. Sky Drive, like, really fucking stupid. There's some stupid fucking shit out there, and not all of it goes the way you think it would go. It's not all common sense, guys. But, I gotta say, I love where we are as Gutter Nerds now.
I really appreciate the fact that this has allowed us to
feel like we've-
rebrand and allow us to focus a little better
We've
than
gotten
we
a
were.
lot sharper, I think.
We have gotten a lot sharper.
Well,
Yeah.
I mean, look at
So-
the road.
She waved at the screen like you could see it. That's awesome. But
I feel like we're all official in our
I
roads.
can see you.
Guys,
I can
thanks for-
see you here.
thanks for hanging out on a rather unusual episode of Scaring.
I want to keep doing this. This is fun.
Yeah.
And I mean, video games and litigation had gone on literally for decades. Our first case was from 1982. So there's plenty more shit going on. Some of it's still in litigation. So even we won't actually have a final word on whether or not any of this stuff has been settled
Yeah.
at all. So we could just bring it in and we'll leave it to the court of public opinion, see what they say about it.
For me, I think of the aftermath. Like,
Mm-hmm.
Sega's probably playing that game, and Ellen Page is obviously playing The Last of Us. And I mean, the guys who sued for Donkey Kong, I guarantee you they're playing Donkey Kong.
And they just recently remade King Kong. Kong lives.
Although King Kong is in the public domain, so you too can make a King Kong movie if you want right now.
We can make a King Chuck.
Chuck Kong.
So what's the building I'm going to call? I'm going to climb. Oh, I already know. Shark is small enough for me to carry in one hand, so she'll be the one that I climb up the tower with.
That's cool. Guys, next week we're going to have Morgan Wagner on from Hangar 13 and 2K Games to talk about Mafia 3. She's a junior mission designer, and so she had a hand in Mafia 3. So we will talk with her. We'll talk to her about her gaming life, about her job, about the game.
It's a great
If you
game. Go
guys
play it.
Want to come and
I would tell you to come watch my stream of it, but I have to stop streaming it because the litigation on the music rights for Mafia 3 are so bad.
when you native stream on the Xbox One, the creators of the game can limit certain aspects of the stream. Metal Gear Solid 5 Ground Zeroes, for example, wouldn't show the ending cutscene if you streamed it. However, if you did it through OBS, it's just normal. It may mute songs if you go back to replay it, you know? But if you did it through a capture card, then what's limiting you is the native Twitch app on the Xbox One. So far as I can
Well,
tell.
F
Which is
you.
But-
I'm going to steal your capture card then.
And I'm
so
going
you
to do
know.
my best to finish playing.
Yeah.
Yeah,
Please
me too.
do.
We got a week.
You got a week.
We got a week.
It's because Chuck and I just stop and listen to the music for a minute while sitting in the car in the game.
But we will be back next week for a really awesome episode in our first dev chat as the Gutter Nerds, so come back and check us out then. If you guys want, you can follow the podcast crew at these places.
I would do my usual pointing, but you can't see me anymore.
Chuck is by Ron Commando on Twitch and on Twitter. Shark is at Killer Shark on Twitter. HedgeHates.com for her webcomic. Calvin and JB are not here tonight. Calvin is Corporate Cal on Twitch. Corporate Hobbs on Twitter. JB is just Gravy Baby on Twitter. It's also his Xbox Live handle. Whoops, slipped. Lauren is at Lauren Lowe on Twitter. And g.n.lauren on Instagram. My name is
Follow
Steven.
us.
My name is
I
Chuck.
am Justice League Lauren.
Right, the Justices. You guys, thanks for hanging out with us. We will see you next week.
Justice!